I am attorney Marie Chris Bathan Lasco. This is my virtual classroom. Welcome to my YouTube channel. In this channel, I shall aim to simplify the law. I shall discuss concepts and principles of law in under 10 minutes. Hello again. Welcome back. In this video, I am going to talk about obligations with a penal clause. Obligations with a penal clause is covered by just 5 provisions of your civil code. That's Articles 1226 to Articles 1230. Now, let's begin. So what are obligations with a penal clause? An obligation with a penal clause is an obligation that has with it an accessory undertaking that tells the debtor that if he fails to comply with the obligation or what is incumbent upon him, or he fails to comply with his promise, then he shall be liable for the penalty. What do you think is the purpose of a penalty? Why do parties to an obligation agree to have a penalty? There are actually 3 reasons behind having a penalty. The first reason is to ensure the performance of the obligation. How can a penalty ensure the performance of an obligation? A penalty can ensure the performance of an obligation because it discourages the debtor from not fulfilling his obligation. Why does it discourage the debtor? It discourages him because his obligation now becomes more burdensome. There is now another undertaking that he must comply because he failed to fulfill his obligation. The second purpose of the penalty is to liquidate the damages that is suffered by your injured party due to the non-fulfillment of the debtor of his obligation. And lastly, the third purpose is to punish the debtor for failing to comply with his obligation. Now, can the debtor exempt himself from the payment or from the fulfillment of his obligation by telling the creditor that he will not pay because he will just pay the penalty? The answer is in Article 1227 of your Civil Code, and it says, the debtor cannot exempt himself from the performance of the obligation by paying the penalty, save in the case where this right has been expressly reserved for him. What does that mean? This means that, as a general rule, he cannot opt to just pay the penalty so that he will not fulfill his obligation. The exception is if that right has been granted to him. In other words, if both the debtor and the creditor have agreed that he can opt to just pay the penalty without paying for or without fulfilling his obligation. Now, how about the creditor? Can he demand for the fulfillment of the obligation plus the payment of the penalty? The answer to that is still in Article 1227, and it says, neither can the creditor demand the fulfillment of the obligation and the satisfaction of the penalty at the same time unless this right has been clearly granted him. In other words, the general rule is no, he cannot demand for the fulfillment of the obligation plus the penalty. That's the general rule. The exception is when the parties have agreed that he may do so. The last statement of Article 1227 says, however, if after the creditor has decided to require the fulfillment of the obligation, the performance thereof should become impossible without his fault, the penalty may be enforced. So again, here, this tells you that if it is without the fault of the creditor and the obligation cannot anymore be fulfilled, then it is his right to enforce the penalty. Now, supposing the debtor fails to fulfill his obligation, and now the creditor is now enforcing the penalty as is his right to enforce it, can the debtor refuse to pay the penalty because the creditor could not show proof that he suffered damage from the failure to comply with the obligation by the debtor? The answer is no. Article 1228 states, proof of actual damages suffered by the creditor is not necessary in order that the penalty may be demanded. This means that what the creditor just needs to prove to enforce the penalty is that the obligor or the debtor failed to comply with his obligation. He need not offer proof that he in fact suffered damages from the non-fulfillment of the debtor. In fact, one of the purposes or reasons why there is a penalty is to liquidate the damages that the creditor may have suffered. And that liquidation of damages will already take the place of proof of actual damages that may be suffered by the creditor. So he need not prove damages to enforce the penalty. Now let's move on to Article 1229. Your Article 1229 gives you circumstances or instances where the courts may reduce the penalty. And when are those circumstances? Let's look at 1129. It says, the judge shall equitably reduce the penalty when the principal obligation has been partly or irregularly complied with by the debtor. Even if there has been no performance, the penalty may also be reduced by the courts if it is iniquitous or unconscionable. So, your penalty, even if you have agreed upon it, the courts may reduce it. When? First is when there has been irregular or incomplete compliance with the obligation. So, for example, the obligation is to pay 50,000 pesos, but you were just able to pay, let's say, 30,000 pesos. If there is a penalty for that obligation, the courts may reduce it because there was already partial compliance of the obligation. If there was irregular compliance, the courts may also decide to reduce the penalty. For example, there was an agreement to paint your house cream, but then what the painter used was not cream but green. There was compliance, however, it was irregularly complied with. The penalty may also be reduced by the courts. Another instance where the courts may reduce the penalty is even if there is no compliance, but the penalty is iniquitous or unconscionable or shocking to the conscience of men. Now, is there a standard yardstick to determine if the penalty is already unconscionable? The answer to that is no. When you revisit cases on obligations with a penal clause or with a penalty, you will see that there is no common or standard measure or yardstick to say that the penalty is already unconscionable. Why? Because it will have to depend on the circumstances of each case. Each case is unique when we talk about your penalty. In fact, in one case, the court or the Supreme Court would decide that a 5% monthly interest is unconscionable. But in another case, it would say that it is not unconscionable. So it really depends upon the circumstances of the case. It will now have to be exercised by reasonable discretion by your court. Again, looking into the circumstances of the case. And lastly, Article 1230. It says, the nullity of the penal clause does not carry with it that of the principal obligation. The nullity of the principal obligation carries with it that of the penal clause. Basic is the principle that the accessory follows the principal, such that if the principal obligation is void, then necessarily the accessory obligation is also void. If it's the reverse, if the accessory obligation is void, it will not affect the principal. The principal may continue to subsist. Now, why is this principle important in the discussion of Article 1230? It is important because, again, a penal clause is an accessory undertaking. It is an accessory obligation, such that if the principal obligation is void, then the accessory penal clause would also be void. However, if it is the reverse, and it is the penal clause that is void, it does not affect the principal obligation. So, for example, if the penalty, supposing, was to sell dangerous drugs, prohibited drugs, if the debtor fails to comply with a principal obligation of paying, let's say, a 100,000 debt, the principal obligation of a 100,000 debt is a valid obligation, but the penalty, that of selling prohibited drugs, that is a void penalty. Will it affect the principal obligation? The answer is no, because again, the principle is that the accessory follows the principal and not the other way around. If, however, it is the principal obligation that is void, supposing the principal obligation is for A to sell prohibited drugs worth 500,000 pesos, and if he is unable to do so, he will have to pay a penalty of 100,000. Here, the principal obligation is void. The penalty, if you take it in itself, is valid because it's just a payment of money. But remember, your 1230 says, if the principal obligation is void, then the accessory will also be void. Because again, the accessory follows the principal. That ends our discussion on obligations with a penal clause. I hope you learned a thing or two from this video. See you next time in MBL Classroom. I hope you learned something from this video. If you have, please click like, subscribe, and that notification bell so that you will be notified of new video uploads. Thank you for watching. See you next time in MBL Classroom.